Ready? For the record, both assistant state attorneys are present, all for defense counsel, and Mr. Rodgers. State's ready? Defense is ready?
Yes, we have one minor issue to discuss.
Sure.
I have seen on people in the gallery buttons of the picture of Teresa Sievers. I would ask those not be displayed as publicity in the courtroom.
State.
Tantamount to T-shirts.
Judge, I saw one person with a button yesterday. We had a discussion and the button was removed. I haven't seen anybody else today with a button.
I saw yesterday, but I saw this morning the nice lady in the black and white who opened the door for me. Thank you very much. But, you know, just in an amount of fairness.
She's wearing a button?
She has a button on her purse. No offense, but it's not proper in the courtroom.
State.
Judge, we'll have a discussion. We had a discussion yesterday.
I'll give you a minute before we bring them out to talk to the individual, but before that, how are we scheduling wise? What are we looking at for you resting your case? How far out? Because we've had a juror send a question to me about it, which we'll get to.
Judge, we're ahead of schedule so far.
2 weeks.
At current pace, when you say 2 weeks, you mean 2 more weeks?
For you to rest, yes, sir.
I think we at current pace, and I don't know, I can't speak for the defense, and it's hard to know how long cross-examination will take. But at current pace, I think we may be able to deliver the case before 2 weeks.
The reason I'm asking is we gave letters to all the jurors. Apparently, I didn't know about it till this morning from the clerk saying they're here. They can't give future letters, and our airline pilot, Mr. Johnson, said he needs a letter saying he will be gone in the future. Otherwise, they don't cancel flights he's flying. And if he's here, then they cancel the flight, and all those people are out of luck. So I'm going to write a prospective letter for him saying he will be gone X number of weeks out. And I don't want to look like a fool and say it's 4 weeks and then have him done in 2.
I'm not anticipating 4 more weeks, Judge. Definitely not.
You see what I'm getting at?
Yes.
Okay.
We figured that we think the defense is saving their fire for a specific number of witnesses, so we've been moving faster than we thought with the witnesses.
I just want to have a rough idea so when I write the letter for him that I'm as close to being accurate as possible.
My best guess, and Judge, and I wish I could make the guarantee, my best guess would be maybe another week and a half.
Okay.
That's at the risk of sounding like Scotty, that you know what I'm talking about. My best guess is another week and a half.
Okay. Okay. Anything else, either side?
Nothing further. I do want to step in the back.
And I'm going to give you a minute to do that, yes, sir. Anything else from the defense? I'm going to ask again anyway after he talks to us.
Sure.
Okay.
Well, I was just going to say, Ms. Ross handed me what is to be a demonstrative aid for the trace evidence analyst, and I would just note my continuing objection on that issue, as I have not been able to depose Ms. Otterstatter due to lack of being provided the adequate information. I further discussed it with Ms. Ross this morning. We asked to know what the software is. If it's a software glitch, I don't know, but what we asked for is not there. And we will be asking for time to depose her prior to trial. But I'd like to be able to review the information first. This is, it was mentioned that the trace evidence is important. We're planning on calling this witness, and we have been denied access to this. So it's my continuing objection, and based on fundamental fairness and due process, the United States and Florida constitutions.
Noted for the record.
Thank you.
Judge, the other FBI expert, the mitochondrial DNA expert, which I'm guessing there's also an objection to, she also sent me a 4 or 5 page PowerPoint that she'd like to, so she can explain what mitochondrial DNA testing is.
We getting to any of those people today?
No.
Okay.
I don't know if this, since we're discussing it, I brought it up.
I would, same objection,
Okay.
same grounds.
Noted for the record. State's ready?
Other than the matter I need to take care of.
Okay.
I think we're ready.
We'll give you a minute or 2 or 5 or. Sure. Yeah, absolutely. Other than the objections previously noted, defense is ready? Okay, bring them out. Please be seated. I'll ask our jurors again, did you follow my instructions not talk about the case among yourselves with anybody else or look up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. State, next witness.
State close, Jamie Nolen.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Good morning, sir.
Good morning.
Can you please state your full name for the record?
I'm Detective Jamie Nolen.
And how do you spell your last name for the record, sir?
Nolen.
Detective Nolen, where are you currently employed, sir?
With the Lee County Sheriff's Office.
How long have you been employed in that capacity?
Almost 17 years.
And during your employment with the Lee County Sheriff's Office, did you become involved in the homicide investigation regarding Dr. Teresa Sievers?
Yes, I did.
What was your initial role in that investigation?
At the time, I was the lead investigator.
And what was the time span of your role as lead investigator?
Probably around 3 months.
And when did that role start?
The day of the incident, which was June 29th, I believe we took over.
And then at some point, was another detective assigned as, were you reassigned and another detective was assigned as lead investigator?
Yes, Detective Downs.
So let me turn your attention then to June 29th, 2015. Did you have an opportunity to respond to the scene involving the death of Dr. Sievers?
Yes, I did. I arrived around 10:45 a.m. in the morning.
And when you arrived there, was the scene contained?
Yes, it was.
There was a person who had called 911. Was that person still present?
Yes, Dr. Petridis, he was still on the scene.
And did you have an opportunity to at least conduct a cursory investigation into Dr. Petridis?
Yes, I did.
And what were the details of that?
I met with him, spoke with him briefly, then I obtained a sworn statement from him. He sat in my patrol car, and I obtained a statement from him for why we were there that day and what he had found.
Was he cooperative?
Yes, he was.
Did he answer all of your questions?
Yes, he did.
And did you have an opportunity to collect any biological samples from Dr. Petridis?
Yes, I did. Due to him being on the scene and finding the victim, I obtained a buccal swab from him and submitted that into evidence. And I also did a search of his vehicle, look for any trace evidence in the vehicle, which showed up negative.
All right, and I'm going to show you what's been previously marked as State's Exhibit. State's Exhibit number 22. Showing you what's been previously marked as State's Exhibit number 22. Do you recognize it?
That's the package I made, which contains the buccal swabs that I took from Dr Petridis at the scene.
Is the packaging in substantially the same condition as it was when you packaged it?
Yes, it does. There's the Lee County evidence tape on there, which has my signature, and at all areas it's unbroken.
And what was the purpose of recovering Dr. Petridis' buccal swab?
Because I knew the crime scene was, of course, going to be at the scene, and they were going to look for any trace evidence, and we didn't have Dr. Petridis' DNA, so this was our way of collecting that.
Well, did you ask for his DNA because he was a suspect in the crime?
No, not at all. He was on the scene, so we need, and he admitted making entrance into the house, so we wanted it to be able to basically put him aside as a suspect.
So if his DNA was found in the home, you want to be able to exclude or include his DNA from the home?
Absolutely.
Is that something that's typically done if you have a person who's not even a suspect in a crime, you still might collect their biological samples?
Yes, it is. We even took samples from the victim's family.
And at some point, did you have an opportunity, speaking of family, did you have an opportunity to meet with Dr. Sievers' husband, Mark Sievers?
Yes, I did, on 2 occasions.
Now, certainly, were you able to establish whether or not Mark Sievers had ever lived in the home at 27034 Jarvis Road?
Yes, I did.
So, his DNA might be something you might expect to find in the home?
Yes, sir.
Since he lived there?
Yes, sir.
But did you also request a biological sample from Mr. Sievers?
Yes, I did.
Okay. And what was the purpose of requesting that biological sample?
Just in case there's, later on in the investigation, that we find other evidence that we can either link him or eliminate him as a suspect.
So even though his DNA, even though his duplicate evidence label, so even though you were requesting his DNA, you still expected to find his DNA somewhere in the home?
Yes, we did.
I'm going to show you what's been previously marked twice as State's Exhibit number 23. And ask if you recognize number 23.
Yes, I do. This is the packaging that I made and placed the buccal swabs inside. With the Lee County evidence tape, all the tape is complete and unbroken, apart from the top where it was taken out by probably FDLE.
So the sample you obtained from Mr. Sievers, according to the tape at least, appears to have been submitted for some additional testing.
Yes, sir.
But with regards to Dr. Petridis, it wasn't.
Does not appear to be, no, sir.
Your Honor, this time I move to admit what's been previously marked as State's Exhibits number 22 and Exhibit number 23 in the evidence as States 22 and 23.
We'll show them admitted.
Okay. Did you have an opportunity to inspect the interior of the home?
Yes, I did.
Was Dr. Sievers still present in the home when you did the inspection of the interior of the home?
Yes, she was.
And we heard earlier that one of the crime scene technicians, Miss Van was involved in some kind of a briefing about the scene. Were you involved in that briefing as well?
Yes, I was.
When you inspected the interior of the home, did you note like an office in the home?
Yes, that was as you walk in through from the garage to the laundry room. The kitchen area is here. The office would be probably at about 11 o'clock.
And did anybody move anything around in the office at all?
Nobody touched anything in there.
After you conducted your inspection and briefing of the home, just a minute, please.
So,
It's early. During your discussion, going back to Mr. Sievers, during your discussion with Mr. Sievers, did you have an opportunity to have his cell phone examined?
yes, I did. We asked him for if we could have consent to search his cell phone. He completed a Lee County Sheriff's Office consent form, and we took possession of his cell phone.
And when you took possession of the cell phone, what did you do with it?
Submitted our evidence section, where they send it over to our digital forensics unit, where they examine it and extract any software, uploads, downloads off the phone.
And did you then return the phone to Mr. Sievers?
It was later returned to him, yes.
Now, at that point, when you did the download from Mr. Sievers' phone, did you know where he had been during the murder of Dr. Sievers?
Yes, we did.
Out of town somewhere?
Yes, he was up with the Sievers family. The victim's family.
But despite him not being present in Lee County when Dr. Sievers was murdered, you still requested his phone to do the download?
Yes, sir.
Okay. What's been previously marked, and it's a composite exhibit, Your Honor. It contains a bunch of other items. What's been marked as states exhibit number 24. It's been marked twice. I'm going to show you what's been previously marked as states exhibit number 24, and ask if you recognize it.
This is there's a property receipt in there stating crime scene log, Sievers consent letter form. There's also.
Let me ask you specifically about the consent form.
So,
The package contains the consent form that Mr. Sievers signed to turn over his cell phone to you.
that's correct.
So you didn't go to the court. You didn't have to go to the court and get a search warrant or a court order. He voluntarily let you download his phone.
Yes, he did.
Okay, if you could go ahead, if we can borrow a pair of scissors from the clerk, you can go ahead and open up number 24 and pull out that consent form, please.
Absolutely.
And you can just move it to the top.
Yep.
And there's some gloves up there if you need gloves.
Wonderful. Thank you. These ones are falling apart. I'll just get another pair. Okay.
Okay, so you located the consent form.
Yes, sir.
Did you provide the consent form to Mr. Sievers?
Yes, I did.
And did he have an opportunity to read it?
Yes, he did.
Did he appear to understand it?
Yes, he did.
And there's a signature on there. Whose signature is it?
Signature is Mark Sievers, as he printed his name underneath it also.
And is there also a second signature present on that form?
There's mine, which notarizes it as a witness.
And it was at that point that Mr. Sievers let you download his phone, or let you have his phone downloaded?
Yes, sir.
Okay. You can put the consent form back into the exhibit, please.
Okay, sir.
At the top, where it can be read. Also, within that exhibit, for the record, were some other documents that at some point you received when you were in charge of, when you were the lead investigator on the case.
Yes, sir.
There's a correspondence there from Mr. Sievers' attorney.
Yes, sir, from Honda and Hanukkah. We
You
received
don't
that.
have to read it, but there's just a letter in there from them.
Yes, sir. We received it on July 8th of 2015.
And then you also mentioned that there was a receipt in there as well.
There's a property receipt here. This is another consent search, I'm sorry, from Robert de la Poor.
And what are the other documents in there?
There is a drawing. I don't know who made the drawing. So. There's a drawing that must have been inadvertently been put in there. And then there's the crime scene log.
Okay. And those are documents that were provided to you during the investigation?
Yeah, yes, they were.
And then you put it in the evidence bag and sealed it up?
Yes, sir.
This time, Your Honor, I move to admit, I'm going to keep all the documents together. Move to admit what's been previously marked as State's Exhibit Composite 24 and evidence as State's 24.
Okay, you guys can approach. I'm going to ask you not to talk about the case among yourselves with anybody else. Look up any people or places involved, and we'll be with you momentarily. How much time do you need, Steve?
My co-counsel actually, I think, has looking at the case right now.
Okay.
Just a few minutes.
Okay. Well,
I just want to make sure that we're clear. We're not putting in, we got two issues here. The first thing is the physical evidence, the cell phone. The second part is the download that was taken from the phone. Right now, the only issue for the state is the fact that the cell phone was taken and downloaded. We're not talking about the actual download itself yet.
we're just talking about the documents and the waiver.
Yes.
Right.
Okay.
I got you.
Okay.
Judge, the one letter from Mr. Halter is clearly hearsay, and that's our objection.
Okay. Just give me a moment. Letter.
Yes, Your Honor.
Okay.
I just want to clarify what I'm thinking.
We can take, we can take the letter out. Again, the
Well,
documents were in the same package, so.
That's what their objection is?
We can take the letter out, and
Okay.
Detective Nolen can take the letter back to the sheriff's office with him, if that's easier.
Well, that sounds like that's all they're objecting to, and if you don't care about the letter, and any objection to doing that?
Just want to make things easier, Judge.
The issue was that
Okay.
it was all in the same packaging, and we were trying to preserve the packaging.
Your Honor, I finally found in the case where perhaps what we're talking about is if I could just have like 2 more minutes to finally.
Sure, I'll give you 2 minutes, but I don't think it's necessary if you guys have come to an agreement. Do we need to put on the record that that's going to be excluded when it's admitted in front of the jurors? I think they heard about the letter, did they not?
They heard that there was a letter from Mr. Sievers' lawyer. Yes.
They may or may not, by the time we get done, remember that. So what's your pleasure, defense? You want me to say something to the jury that it's been admitted, but it's excluding the letter from Mr. Hanukkah, or do you want me to just not address the issue? Okay. And while we have everybody out, we'll give them enough time to use the restroom. Does anybody else need to use the restroom? Okay, we'll take 5 minutes and everyone's good. Move the letter, you have it, or?
The letter has been removed.
Okay.
And Detective Nolen was asked to take that back and repackage it, and the other items were placed back into the exhibit number 24.
Okay, you can bring them out. Please be seated. I'll ask our jurors again, did you follow my instructions, not talk about the case among yourselves or with anybody else, or look up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. And that's number 24, correct?
Yes, yes, Your Honor.
We'll show number 24 admitted, with the exception that the letter from Mr. Hanukkah has been removed from that exhibit.
Your Honor, at this time we tender the witness.
Sir. Defense.
Morning, Deputy Nolen. Morning. How are you? You were lead detective on this case originally.
Yes, sir.
And that lasted 3 months. You were replaced by Detective Downs.
Yes.
What was the reason for that?
I switched to
Objection, relevance.
When you arrived on the scene, you were one of the first people to arrive on this scene on Jarvis, correct?
Yes, sir.
And when you arrived, that scene was already secured.
Yes, sir.
You met with crime scene technician Van Was at the scene?
Yes, sir.
Okay. And did you take crime scene technician Van Was on a walkthrough?
We do an initial walkthrough, yes, sir.
You and Ms. Van Was were in the kitchen, of course.
Yes.
And while you were there, was the body of Dr. Sievers still present?
Yes, it was.
You'd been a detective at that time for how long?
At the time, 2015, about 11 years, sir.
So you'd been to many crime scenes,
Yes, sir.
many homicide scenes.
Yes, sir.
You have training in blood analysis.
That's more forensics. We have some training going through medical legal homicide training, yes.
So in your capacity as a homicide detective, you're familiar with blood analysis.
Yes, sir.
Are you familiar with a term cast off?
Yes, sir.
Objection, beyond the scope of direct.
Overruled.
And cast off is a type of blood spray that occurs when a weapon hits a blood source, correct? And then is removed from the blood source,
Yes, sir.
creating a spray of
Objection,
blood.
compound question.
Overruled.
Is that correct, sir?
Yes, sir.
There are ways to analyze cast off where it can be determined whether it's forward cast off or reverse cast off, correct?
I'm unaware of that, sir. This is not my expertise.
But cast off is something you're familiar with.
Yes, sir.
You recognize it when you see it.
Yes, sir.
You didn't see any cast off at this site, correct?
Most of the blood level was at a lower level, yes.
Now that blood that was at a lower level, that blood is characterized as being spatter, correct? That's a different type of blood spray.
Yes, sir.
So that blood occurs, that type of pattern occurs when a source is, there's an established blood source, a wound, and an item, a weapon hits that blood source, and causes dispersion, correct?
Yes, sir. There are other factors as well, though. If there's something blocking the cast off from making its transition from in direction, then that's going to also diffuse. That can change how the blood spatter actually happens.
But that's more of a theoretical statement. That's speculation. That wasn't your observation here.
Counsel's testifying.
Sustained.
The dispersion of the blood that you observed on the site in the kitchen was very low, correct?
Yes, sir.
You observed no blood on the ceiling,
I didn't observe any, no, sir.
no blood on the walls above about 2.5 feet.
No, sir.
That's all I have, Detective. Thank you.
Thank you.
Detective Nolen, since we're going to talk about blood, did your, based on your training and experience, did you see any indication that Teresa Sievers was killed anywhere else other than in that kitchen?
No, sir.
Did the blood spatter or lack of cast off indicate that Teresa Sievers was not bludgeoned to death?
Objection calls for speculation.
Well, we just talked about it.
Overruled.
Did your training experience indicate regarding the blood spatter, lack of cast off, indicate to you that Teresa Sievers was not bludgeoned to death?
No, sir.
Were there any conclusions that you made from reviewing the blood spatter that were inconsistent with the scene as you observed it that day?
With the violent damages to Miss Sievers' head and the amount of blood that was on the ground, I was surprised that it wasn't cast off on the ceiling.
But there was blood spatter in the vicinity of Dr. Sievers.
Yes, there was, and pooling as well.
And that blood spatter and that pooling were consistent with her injuries?
Yes, sir.
Thank you.
But once again, as you told ASA Hunter, you were surprised that there was no cast off.
Yes, sir.
Nothing further.
This witness to be released or retained.
He's free to go, Your Honor.
No objection, defense?
He's released.
Okay, you're free to go.
Thanks,
Thank
sir.
you, sir.
And I'd like to approach with number 24, please.
Yes, sir.
Thank you.
Next witness.
State calls Kevin Stout.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Good morning.
Good morning.
Would you state your name for the record, please?
My name is Kevin Stout. I go by KC
Casey. And where do you work?
at the Lee County Sheriff's Office
And how long have you worked there?
since 2003.
And in what capacity do you work at the Lee County Sheriff's Office?
I'm currently the Digital Forensic Supervisor.
And as the digital forensics supervisor, what is digital forensics?
We basically recover evidence from computers and cell phones, any kind of digital media that we come across.
And have you had training in the area of digital forensics?
Yes, ma'am.
What training have you had?
I got a certification. It's called a Certified Forensic Computer Examiner. It's through the International Association of Computer Investigative Specialists It's a pretty intense 2-week course that you take in class where they're teaching you the ropes of and introducing you to all kinds of tools and equipment and how to recover data. Once you go through that class, you're assigned a coach, a mentor, and you're given 4 practical examinations where you're practicing how to recover data, how to recover dates and times of files, recovering internet histories. If there's anything that you may have missed or may have not realized how to get that kind of data, your coach that you're assigned helps you through that process. Once you pass all those 4 examinations, you're then pushed on to the next phase where you are given a digital copy of a hard drive, and you then independently recover that same data you recovered the data in the practicals. You're now doing it as an independent examination where you're running a full examination report as if it's a real scenario. You're recovering deleted data, you're recovering internet histories, the same process that you were in the practicals. Part of that, they throw in a hidden or encrypted file that you're supposed to find and locate and recover, and it ends up being a 100-question test where then you have to pass that test.
And you did all of that?
Yes, ma'am.
And so you are a certified forensic computer examiner?
Yes, ma'am.
Have you had, do you also belong to the International Association of Computer Investigation?
Yes, that's who sponsors the CFCE.
And as part of just that association's membership, are there a certain number of hours every 3 years that you must continue to complete to maintain even a part of that initial membership?
Yeah, to retain your certification, yes, you have to take 40 hours of training specialized in the computer forensics world. Technology changes constantly, so you're constantly having to go to classes. So they require that, yes.
Have you been trained in more than one type of software?
Yes, ma'am.
And have you been trained in the various data recovery companies?
Yes, ma'am.
And it sounds like you've been trained in cell phone data recovery.
Yes.
Were you asked, as part of your duties and responsibilities at the Lee County Sheriff's Office, to examine a number of devices pertaining to the investigation into the murder of Teresa Sievers?
Yes, ma'am.
And let me just start with this. When you receive a cell phone in the digital forensics unit, what is the first step or procedure you use when you are handed a cell phone?
We always want to make sure that no changes are made to the device. So we'll put it inside of a box called a Faraday box, and it blocks all signal from gaining into the phone. So nothing can be changed, nothing can be wiped or anything like that. It keeps it secure.
And once you place it in the Faraday box, are you able to do something to it so that you can then remove it from the Faraday box?
Yes, ma'am. When it's in there, you put it in what's called airplane mode, which you're disabling your wireless connection, you're disabling your cellular connection, and we'll also take extreme measures and or you remove the SIM card out of the cell phone.
And when did you receive a cell phone on June 29th of 2015?
Yes, ma'am.
And did you follow the same procedures that you've just described for the ladies and gentlemen of the jury?
Yes, ma'am.
And during the processing of that phone, did you determine what the number of that phone was, the phone number?
Yes, ma'am.
And was that 314-239-0173?
Yes.
Once you had removed that phone from the Faraday box, what was the next step in your processing of that phone?
I hooked it up with a USB cable to a cell phone forensics tool called Cellebrite. The Cellebrite's just a one of our main forensics tools that we use to extract and copy the data from a phone in order to transfer it to our forensics workstations.
Now, when it copies the data from the phone, does it leave the data in the phone as well?
Yes, ma'am.
So when you return a phone, it's got everything it had in it when you started.
Correct.
And with Cellebrite, can you create reports that put information that's retrieved in a readable format?
Yes.
Tell the ladies and gentlemen of the jury about that.
So after we copy the data, the Cellebrite has a tool where it will parse out all the data, and it goes line by line and categorizes it into, if, for example, if it sees a line of code where it sees that it's a text message, it'll put it in a text message category. If it's a email, it puts it in an email category. Contact goes into contact. So it categorizes it for you.
And did you perform that? Did you do a complete, what would you call it, extraction on the phone that you were handed when you hooked it up to Cellebrite?
Yes, ma'am.
I'm going to show you what's being marked for identification as State's Exhibit number 25. If I may approach the witness, Your Honor.
You may.
What is State's Exhibit number 25?
It's the cell phone forensics report from Cellebrite.
And
that
is
phone.
this the extraction that you obtained from device number, phone number 314-239-0173?
Yes, ma'am.
And is that an accurate, what's in your hand? It's certainly not paper.
No, it's the digital copy that's on a thumb drive.
And so you place that digital copy on a thumb drive?
Correct.
And is this an accurate, does that thumb drive contain an accurate copy of the extraction that you performed using Cellebrite on the phone number with area code 314-239-0173?
Yes, ma'am.
Move to introduce.
Can we approach?
Sure. Okay.
Thank you, Your Honor. Your Honor, I am showing to defense counsel what I've marked as State's Exhibit 25A. If you could give me just a moment, Your Honor.
Yes, ma'am. Okay. My apologies. You ready? My apologies again. We'll be with you all shortly. If you'll please not discuss the case among yourselves or with anybody else, or look up any of the people or places involved, it'll be short. Please be seated. Who else are you calling this morning?
Judge, we have four more witnesses in the back for this morning.
I'm going to ask both sides to go through anything you're going to try to move into evidence so we can take care of any issues like this in advance. This should not be a stalling issue, what we're doing right now for the trial. I'm going to ask over lunch that you do the same thing. We'll be in recess. Let me know when everybody's ready.
All right.
Okay, we're back on the record. We have both Assistant State Attorneys present, all four defense counsel, and Mr. Rodgers.
Your Honor, I thought before the jury came back in, we could finish addressing
Yes, ma'am.
this issue. So I'm not sure who was left to speak next, but let me just, I think it was Mr. Darrow who would say whether or not he's objecting to 25A.
Judge, the state's provided me an exhibit, and they pointed out the particular text messages that they're interested in, so that does make things a lot easier, and I appreciate the court giving me time to review that. Everything in this document to start with is text messages, which is hearsay under the Gale case. The state would need to establish exceptions to that. I would point out, first of all, that the ones that they're not interested in should not come in because they have nothing to do with this case. There's all kinds of different discussions involved there, including discussions of, I believe, patients and medication and things like that. As far as the specific ones that they're going to, I would first start at the first one that they're looking for, which is, it says, hopefully we can talk privately tomorrow, nothing about you or Angie, but it's personal. That's dated April 29th, 2015. I would point that is outside of the time frame of the conspiracy that the state is alleged in the indictment. They alleged it beginning April 30th of 2015. In short, I don't see any exceptions to the hearsay for that or any of the other statements with the evidence we have before us right now. Again, the state may be able to present testimony that ties that up. There's also nothing has been presented as to whose phone this is, so it hasn't been authenticated. If you look at, I'm pointing out on page 41108, that's the discovery page number. They've highlighted one that's entitled, it's a text from, allegedly from Mr. Sievers to Mr. Wright, entitled, "Thought this was funny from Facebook, best divorce letter ever." It's clearly a joke, and if the state had included the next few pages of discovery, of this report, that includes the fact that this joke was sent to numerous people, including Dr. Sievers. So I don't see how that particular statement could possibly be in furtherance of a conspiracy.
I do want to start with the extraction report itself, because the Gale case, which was presented by defense counsel to the court, states in that case that their holding on this issue conforms to the decision in Jean-Philippe versus State, 123 Southern 3rd, 1071, Florida, 2013. And it notes that in that case, the court affirmed the admission of text messages downloaded from a phone by law enforcement officers. It then talks about what Philippe was focused on. They also note in that particular opinion that an extraction report is admissible, because here's what the conclusion of the court starts with. Because the extraction report was not hearsay. So the extraction report of a phone is not hearsay, and that extraction report is admissible. So just in terms of the extraction report. Next, the Philippe case, which I do have a copy of for the court, if the court would like it.
Sure.
Which is the case that is cited within the case provided by the defense, makes clear that these text messages are admissible. And particularly, I would refer the court to what is on page, 8 of what I've handed the court. It's on page 1080 of the opinion. So I think, Your Honor, that text messages are admissible for introduction. As to the comment by Mr. Darrow regarding the text message of August 29th, the state's information alleges that the conspiracy occurred between April 30th forward. But that text message is an invitation to a conspiracy. which would be different than a part of the actual conspiracy. And so the state submits that it too is admissible.
Judge, can I respond very briefly?
Sure.
Judge, yes, what the state is saying is halfway there as far as the extraction report being not hearsay. The argument that was made, I believe, by the defendant in Gale was that there were two levels of hearsay, extraction level and then looking at the individual text messages. Gale makes it very, very clear, and so does John Philippe, that just because it's an extraction report doesn't mean it automatically comes in. It just means that there's not a whole other level of hearsay there. It's not hearsay within hearsay. The conclusion in Gale is because the extraction report was not hearsay, and because the state established an exception to the hearsay that was appellant's own statements, we affirm the trial court's condition. So very key in the Gale decision is the fact that there has to be an exception for the content to come in.
Okay. Any other things that you're looking to introduce that we're going to have a problem with the other witnesses coming forward that we need to address before I go read the Philippe case?
Your Honor, not today. And we have provided to Mr. Darrow the other specific pages from another extraction that is not being introduced today, Your Honor.
I'll review that.
At least it's not the intent of the state to call that witness today, so that Mr. Darrow would have an opportunity to review those pages before the next court case.
After this issue is resolved one way or the other, how much time do you have left with this witness, and who's next, and how long will they take?
I'm sorry, Your Honor. Would you repeat that?
Irregardless of the ruling on this, how much time do you have left with this witness on the stand? Who's next, and how long will they take?
Your Honor, I have, I was going to say about as much time as we've used up to this point, but that provides the court no information. At most another 15 minutes. That might be a more accurate way to phrase it. So probably another 15 minutes with this witness. Our next witness is Deputy Armato from the Lee County Sheriff's Office. He will be a brief witness. The witness following him is Gladys Martinez. She was part of the crime scene that went to autopsy and recovered items from autopsy. Those have been shown to the defense before now. I mean, they were shown to the defense during the break, so they're aware of those items. And then we have, I believe, Lieutenant Downs testifying. All of the items that would be referenced to him have been brought into the courtroom, and during the break, Ms. Fitzgeorge and I went through each of those items.
Okay. And you still have withdrawn your motion on 25. We're just dealing with 25A and those particular texts that were extracted, correct?
Yes, Your Honor, I withdrew it at that point because if 25A, yes.
I'm asking because we were talking about two different things,
Right.
even though we were only recessed on one.
Right. What I'm saying by withdrawing it is if 25A is coming into evidence, the state will withdraw any attempt to introduce 25.
And my guess is that 25 is the whole extraction, so what I'm saying applies 100 times from this to that.
Well, that's the complete extraction report, correct?
Correct.
Okay. All right. Give me a little bit of time to go read the other case you just have given me.
Thank you, Your Honor. And Your Honor, as always in any case, the state would submit that 25 is admissible, but what goes back to the jury is different than what is admitted in court. So the state did not seek to have State Exhibit 25 go back to the jury. Rather, just to have 25A go back to the jury. It just makes clear that that came from that extraction.
Yeah, 25 is a thumb drive, right?
Correct.
Right. Okay. Yeah.
Exactly.
I really don't want the jury back there with the thumb drive.
Well,
But
they have
that's-
no way to access it
Well, then they can
because I don't give jurors computers, and that's why I'm trying. And I don't let them take them back there either. So I was just making sure I got it.
Right.
Okay. I'll be back.